The companion to the Open Meetings Law is our Freedom of Information Law. Many people call it FOIL. FOIL deals with all government agency records, and in New York, the term record is defined very broadly to mean any information in any physical form whatsoever that is kept, held, filed, produced, or reproduced by, with, or for a government agency, which can include a state agency, a city, a county, a town, a village, even a public authority or a school district. They are all agencies that are covered by our Freedom of Information Law. Like the Open Meetings Law, FOIL is based upon a presumption of openness. Very basically, all that law says is that all government records are available with certain exceptions. And those exceptions are primarily based upon the potential for harm should the government disclose. So the key question typically is, what would happen if the government disclosed? And unless the answer is, ouch, this would really hurt, either somebody in terms of an invasion of personal privacy, the government in terms of its ability to do its job on behalf of the public, or on occasion, a private company in relation to its competition, the government agency will be required to disclose. The first point to make about FOIL is that the title of the law is at least a little bit wrong and misleading. Why? It is not an access to information law per se, it is an access to records law. FOIL is not a vehicle that gives John or Jane Q. Public the right to cross-examine public officials. If you want to answer people's questions, that's fine. We do it all the time. But that is not an obligation imposed by the Freedom of Information Law. That statute deals with existing records, and in general, we are not required to create a new record in response to a request for information. Second point, equally important, our law in New York defines what a government agency record is. And since '78, the law has defined the term record to mean any information in any physical form whatsoever, kept, held, filed, produced, or reproduced by, with, or for a government agency. So it doesn't matter what its function might be. It doesn't matter where it came from. If government has it and it stores information, whether it's the 8.5 by 11 sheet of paper, the content of a database, email, a videotape, all of those things that store information by or for the government constitute government agency records that fall within the framework of the Freedom of Information Law. The extent to which they must be disclosed is the next question. The Freedom of Information Law is based upon a presumption of access. Very basically, it says that all government agency records are accessible, with the exception of those records or portions of records that fall within a series of exceptions. One of the exceptions deals with the kinds of communications that you're talking about. And my suggestion is that you consider email communications in the same way that you would consider paper communications. The law does not distinguish. Email is simply a means of communicating a record. And certainly, we cannot consider email to be the equivalent of a conversation because it's there. It is stored. And in fact, even if we hit the delete key, it's still there. It is still subject to rights conferred by FOIL. More importantly, it may be subject to discovery or subpoena in the context of a lawsuit. Email between or among government officials. The exception that deals with that issue, and it cuts in two directions, deals with so-called interagency and intra-agency materials. How many of you are old enough to have taken Latin? Yeah, then some of you remember that interagency would involve those communications between or among government officers or employees, from one town board member to another, the memo from the town clerk to the board. Those would be intra-agency materials, in-house. When you send me an email from your unit of government to me at the Department of State, they would be interagency materials. Again, your communications between or among each other would be intra-agency materials. The Court of Appeals, the state's highest court, has looked at that exception and given us guidance concerning its intent. And the notion is to enable government officers and employees to express their opinions, their recommendations, their advice without an obligation to disclose. However, the exception says that 4 categories of information within interagency and intra-agency communications have to be disclosed unless there's some separate exception that authorizes the agency to say no. And they're important. Within those communications, number 1, the law says that, quote, statistical or factual tabulations or data have to be disclosed. The courts have construed that phrase to mean statistical or factual information, irrespective of how it might appear on the page. It might be numbers and rows or graphics or something like that, but it might also be a narrative expression of fact. I looked out the window and the sky was blue. Factual information. The courts have also told us that statistical information includes estimates and projections, even though they may be draft or other than final. The law also says that within those internal governmental communications, instructions to staff that affect the public are accessible, as are final agency policies or determinations. Some have characterized those two in combination as the secret law of the agency. Those are the items that you'll never find in the law books in the library, but you might find in an agency's staff manual or procedure book or policy book or whatever it might be called. And finally, the law requires that external audits be disclosed. So if the comptroller or somebody else outside of your agency prepares an audit, it is public, even though it usually will consist of a combination of statistical and factual information as well as expressions of opinion or recommendations. The question involves fees under the Freedom of Information law. The only fee that we can charge involves the duplication of records. And generally speaking, the maximum that we can charge is 25 cents per photocopy up to 9 by 14 inches, or the actual cost of reproducing something else, such as a tape recording or information that is maintained electronically. We cannot charge for personnel time. We cannot charge for search. That is not something that the Freedom of Information law permits. If a government agency has the ability to accept requests made by email, it must do so. More importantly, if an applicant asks that information be transmitted via email, if you have the capacity to do so with reasonable effort, you are required to do so. That means that people can make requests at 4 in the morning. That means that people often can get an awful lot of material quickly and easily. It also means, since the only fee that we can charge in New York under our Freedom of Information law is for the duplication of records, that it's free. It's free. When an agency receives a request, the law says that the agency has 5 business days to respond in some manner. Within that time, there are several choices. Number 1, the agency can say, yes, you can have it. Here it is within the 5 business days. Or the agency can say, sorry, you cannot have it, in which case a denial of access must be given in writing, and the applicant must be informed of the right to appeal. The appeal goes to the governing body or somebody designated by the governing body to determine appeals. Next option. Let's say that more than 5 business days is needed. The obligation in that situation is to acknowledge the receipt of the request within that 5 business day period, and if it's believed that the agency can grant the request in whole or in part within 20 additional business days, again, it is required to provide an approximate date within that 20 business day period, indicating when it believes it will be able to grant the request in whole or in part. And the law says that if that approximate date is reasonable, the agency is complying with law. There are situations in which a delay may be unreasonable. If somebody goes into the town clerk's office and asks for the minutes of last month's meeting, they're clearly public and they're right over there. it seems to me that a delay, even beyond 5 business days, would be unreasonable. Let's say that there is an exceedingly large and complex request, and the agency needs more than 20 business days. In that situation, the obligation is to acknowledge the receipt of the request within 5 business days, to provide an explanation for delaying beyond 20 business days, and to provide a date certain, a specific date by which the government agency promises, swears, yes, we will make the records available in whole or in part by such and such a date. Again, if that date is reasonable based upon the facts, the agency would be complying with law. When an appeal is made, the agency has 10 business days to do one of 2 things: to make the records available or to fully explain in writing the reasons for further denial. The court is authorized to award attorney's fees if you are sued if certain conditions are present. Number 1, the applicant must substantially prevail. Number 2, the court must find either that the agency had no reasonable basis for withholding or that it failed to meet those time limitations that I mentioned a moment ago. The law says that an applicant must reasonably describe the records. Let us not confuse reasonably describing with specificity. Insofar as we can locate whatever it may be with reasonable effort, the request meets the standard of reasonably describing. But on the other hand, insofar as the search would involve going through the haystack in an effort to find the needle, even if we know the needle is there, it would not reasonably describe. That's where somebody from the government should probably get in touch with the applicant and say, sorry, we maintain the records this way, not that way. Let me give you my silly phone book example. Let's say that, what county are you from? Saratoga County. Somebody walks into the town office and sees the Saratoga County phone book and says, aha, a government agency record. What's your last name? You can lie if you want. Smith. I hereby request all of the listings in the phone book for those people whose last name is Smith. Piece of cake. That's how the phone book is written. Last name, alphabetical order. Even if there are 10,000 Smiths, the request would reasonably describe the records. Huh. What's your first name? Mary. Okay. Same person walks in and says, now I want all of the listings in the phone book concerning those people whose first name is Mary. Huh. The request is specific. You know that there are Marys there, but you can't find them unless you go through each listing one by one. In that situation, again, that's where you tell the applicant, sorry, we maintain these records by last name in alphabetical order, not by first name. Your request does not reasonably describe the records. If you can make your request in a manner that is consistent with our record-keeping system, we will be happy to accommodate you. One other twist, let's say that you have a search engine now, and you have the capacity to enter whatever it may be and pull up all the Marys. Court of Appeals has told us we have to do that to comply with FOIL. Extracting those portions of the record is not the equivalent of creating a new record. It is simply disclosing portions of an existing record. One of the exceptions to rights of access appearing in the Freedom of Information Law involves the protection of personal privacy. And it says that government has the ability to withhold records or portions of records when disclosure would result in an unwarranted invasion of personal privacy. Now, I'm not going to suggest that anybody knows what that clearly means, but the courts have given us guidance. One area of judicial decisions involves the privacy of ordinary people, and the Court of Appeals has used common sense. All the court has told us is that the government has the ability to withhold those kinds of items which, if disclosed, would be offensive to the reasonable person of ordinary sensibilities. So if it's one of those items that the average citizen would consider to be offensive or intimate, if disclosed, chances are pretty good that the government has the ability to say, sorry, no, you can't have it. On the other hand, the law has been interpreted differently with respect to the privacy of people like me, government employees. it is clear that we have less privacy than anybody else because we're supposed to be more accountable than anybody else. The courts have held in so many circumstances that those items about public employees that in some way relate to the performance of our official duties are public, because disclosure in those circumstances would result in a permissible, not an unwarranted invasion of personal privacy. So if you want to find out the salary of any public employee, it may be the governor, it might be me, it might be the teacher in your school district, you have the right to know. What you wouldn't have the right to know, for example, would be my Social Security number. Why? Because that has nothing to do with how I do my job. But the bottom line is that the law requires accountability on the part of government as well as its employees. The courts have given us guidance, and the courts have gone off pretty much in two directions. The first involves records maintained by the government that identify ordinary people. And what the Court of Appeals has told us is, react from the gut. What would the reasonable person of ordinary sensibilities feel about disclosure of this item? Is it one of those things where you'd say to yourself, this is nobody's business, this is offensive, this is intimate, it's medical information, mental health information, personal financial information? If it's something like that, chances are pretty good that we have the ability to say no, because disclosure would result in an unwarranted invasion of personal privacy. The second branch of case law deals with people like me, like you, public officers and employees. And the courts have told us pretty much two things, and these are very general statements. Number one, we have less privacy than anybody else. Why? We are supposed to be more accountable than anybody else. Secondly, and more importantly, in numerous situations, the courts have looked at records pertaining to public officers and employees and said that those items that are relevant in some way to the performance of our duties typically are public. Why? Because disclosure would result in a permissible, not an unwarranted invasion of privacy. Conversely, if an item is irrelevant to the performance of one's duties, it can be withheld. Simple example. When I drive my car to give a talk to an organization in the performance of my official duties, when I go back to the office, I want to be reimbursed. I will submit a travel voucher. It'll indicate what I did, where I went, how many miles I put on the car, the tolls, whatever my expenses might be. Each of those items clearly would relate to my duties. There's no doubt that they would be public. But to be paid, I also have to include my Social Security number. That has nothing to do with how anybody carries out his or her duties. There is no doubt that the Social Security number could be deleted prior to the disclosure of the remainder, because disclosure would result in an unwarranted invasion of my privacy. And with that, my final words are, if ever you have a question or a problem involving either FOIL or the Open Meetings Law, pick up the phone, drop us a line. We will be more than happy to help. And again, I thank you.